By the time Janet's lawyer asked the judge for a recess, the survey overlay was already on screen. Her parking lot's edge cutting 6 feet into my deeded property, right through the spot where my grandfather's heirloom tomatoes had been growing for 11 years. The contractor she'd hired was staring at his boots. 2 board members were pretending to read their phones. And Janet herself, the woman who had smiled through every lie she'd ever told that community, was finally looking at something she couldn't talk her way past. A boundary she didn't own and asphalt she couldn't explain. That's where this ends. But it started in the dirt, the way most honest things do. I bought that house 9 years ago. Corner lot, mature oaks, south-facing backyard with enough sun to grow anything that wanted to cooperate. It sat at the edge of a subdivision that had an HOA, but my parcel was recorded separately. Different plat, different survey. Not part of the association and never had been. I confirmed that before I signed. I confirmed it again after I moved in. And I kept the paperwork because that's what I do. Not because I'm paranoid, because I'm a land use attorney and I know exactly how people lose property they thought was theirs. The garden came first. I built 12 raised beds over the first 2 summers. Cedar frames, hardware cloth bottoms, triple mixed soil I hauled in myself. Then came the perennials, lavender along the south fence, black-eyed Susans near the gate, a row of blueberry bushes I trained along a wire trellis. By year 3, that garden was producing more than I could eat. I gave tomatoes to the mail carrier. I left zucchini on neighbors' porches when they weren't looking. That backyard wasn't decoration. It was alive. And it was mine in a way that went deeper than paper. Janet Wynne showed up the summer I added the cold frames. She came around the side gate without knocking, stood on my flagstone path in cream heels that had no business touching soil, and introduced herself as the president of the Homeowners Association. She had a black folio under her arm and a smile that had been polished so many times it reflected nothing. She said the community was planning a parking expansion for a new clubhouse amenity. She said the board had approved preliminary drawings. She said the logical extension of the east lot would require adjusting the boundary between the shared space and my property. Adjusting, she said. Like she was moving a chair at a dinner table. I told her my lot wasn't part of the HOA. She blinked once, then recovered. We understand that technically the plat is separate, but the community's needs have evolved, and we believe a voluntary easement would serve everyone's interest. Voluntary, I told her, means I get to say no, and I'm saying no. She left without argument, which worried me more than if she'd yelled. People like Janet don't retreat. They redirect. They go back to their kitchen tables and their board emails, and they start building a version of reality that doesn't need your consent. I've seen it 100 times in my practice. The smile walks away, and the machinery starts turning. That night, I walked the entire fence line with a tape measure and my phone, photographed every post, every survey pin, every inch where my gravel met their asphalt. I measured the distance from the county iron pins to the edge of the HOA parking lot, 14 feet, 2 inches of clearance on my side. Then I pulled the county GIS file online and printed the parcel overlay at full scale, taped it inside my garage where I could see it every morning. I also filed a preemptive boundary confirmation request with the county assessor's office. Cost me $40 in 2 forms. Most people don't know you can do that. I do. 2 weeks after Janet's visit, I noticed a county utility locate request had been called in for the edge of the HOA lot. The markings went beyond the lot line. Someone had requested paint flags across my property without my authorization. I called the utility company, and confirmed the request came from a contracting firm I'd never heard of, same firm whose name would later appear on Janet's paving contract. Then the first orange stake appeared. It was 6 inches inside my fence line, driven into the ground between my blueberry trellis and the compost bin. No notice, no letter, no knock. Just a wooden stake with a pink ribbon and the contractor's code stamped on the side. I photographed it, pulled it, and mailed a certified letter to the HOA board citing the recorded boundary and demanding they cease all encroachment activity within 7 business days. Janet sent back a form letter. It thanked me for my input and said the project was proceeding under the board's authority to manage shared infrastructure. The word shared was doing a lot of heavy lifting in that sentence for a project that was entirely on my land. Then the trucks came. I was at the county courthouse filing a motion on a client's drainage easement when my neighbor Deborah called. She said a paving crew had pulled into the HOA lot at 7 in the morning with a small excavator, a dump truck of gravel base, and a roller compactor. By the time I got home at noon, they had removed my fence, crushed 4 of my raised beds, torn out the blueberry trellis, and laid 5 inches of gravel base across a strip of my backyard, 12 feet wide and 40 feet long. 3 of my cold frames were in a dumpster at the curb. The bean poles were snapped. 11 years of soil amendment, composted, turned, balanced, tested, was buried under road base. I stood at the edge of that gravel and felt something I don't usually feel. I'm trained to stay analytical. I read setback ordinances for a living. I argue boundary disputes in front of administrative judges. But standing there looking at what had been my grandfather's garden, now flattened under gray stone and tire tracks, I felt the kind of anger that doesn't make noise. It just hardens. I didn't yell. I didn't confront anyone. I took 67 photographs, shot video of every tire mark, every broken frame, every survey pin they had pulled and discarded in my side yard. I collected the HOA's contractor placard from the cab of the parked truck and wrote down the license plate of every vehicle in the lot. Then I went inside, sat at my kitchen table, and opened a blank legal complaint on my laptop. If you want to see what happened when this got to court, subscribe to HOA Wars and tell me in the comments, have you ever had someone destroy something you built with your own hands? The filing landed 3 days later. I didn't use a firm. I wrote it myself. Trespass, property destruction, unauthorized encroachment, conversion of personal property, and intentional interference with use and enjoyment. I named the HOA as an entity, Janet Wynn individually as directing officer, and the paving contractor as agent. I attached the survey, the GIS overlay, 26 time-stamped photographs, the certified letter I'd sent 3 weeks before, and Janet's form letter response proving she had been notified and proceeded anyway. The temporary restraining order came the next morning. Judge signed it before lunch. The paving crew was ordered to stop all work within 50 feet of my recorded boundary. A sheriff's deputy served it at the site by 2 o'clock. I watched from my kitchen window as the foreman read the paper, pulled out his phone, and walked away from the equipment without looking back. Janet's response came through her lawyer. A motion to dismiss arguing that the boundary was in dispute and that the HOA had relied on good faith community planning documents. I read it twice and almost smiled. She had attached her own map, and her own map showed the parking expansion crossing my parcel line by exactly the amount I had claimed. She had just entered into evidence the proof I needed. The hearing was 5 weeks later. Small courtroom, county level, no jury. Janet wore a navy blazer. Her attorney had a slim binder. I had a box. Inside that box was every document I'd collected since the day I closed on the house. The deed, the survey, the GIS printout, the HOA's own covenant boundary map, which excluded my lot, the certified letter, her reply, the contractor's work order, which listed the area by GPS coordinates that fell inside my parcel, the photographs, the video, the cost receipts for every raised bed and plant I had installed, and a soil analysis from the county extension office showing the amendment profile of soil that had been cultivated for over a decade. Janet's attorney went first. He argued community benefit. He argued that the boundary was ambiguous. He argued that the paving project had been approved by a vote of the full board. He used the word reasonable 4 times in one paragraph. Then I stood up. I didn't argue. I showed. I put the county survey on the overhead projector. Then I laid Janet's own submitted map over it. The overlap was exact. Her parking lot ate 6 feet of my garden across a 40-foot stretch. I showed the certified letter proving notice. I showed her reply proving she ignored it. I showed the contractor's GPS log proving he was directed to pave inside my boundary. I showed the before photographs, 12 raised beds, a blueberry trellis in full fruit, cold frames with late-season greens. Then I showed the after, gray gravel, broken cedar, tire treads where bean poles used to be. The judge asked Janet's attorney one question. Did your client have any recorded easement, license, or legal right to perform work on the plaintiff's parcel? He said no. The judge asked a second question. Was the plaintiff's certified notice received before the paving work commenced? He said yes. The courtroom was quiet in a way that has weight. Not silence from confusion, silence from clarity. Everyone in that room understood what had just happened. Janet's own filing, her own map, her own contractor's GPS data had done my work for me. She had walked into a boundary dispute carrying the evidence that proved there was no dispute at all. She had simply taken what she wanted and assumed paperwork would fill in the gap later. That was it. The court granted my injunction permanently. The HOA was ordered to remove all paving material from my property within 14 days, restore the grade to its original condition, and reimburse me for every dollar of documented loss. The raised beds, the soil, the plants, the trellis, the cold frames, the labor, and the crop value I had lost for the season. The total came to $41,000. Janet's contractor was separately cited for operating without verifying property ownership, which voided his county work permit for 90 days. Janet was removed from the board by a vote of the homeowners at the next quarterly meeting, not because they suddenly believed in justice, because the settlement came out of the HOA's reserve fund, and every member got a special assessment on their next dues statement to cover it. $41,000 divided among 112 units makes people care about boundaries they never thought about before. 3 board members who had voted to approve Janet's expansion plan resigned the same week. The contractor's insurance carrier sent a separate check for the cold frames and the blueberry trellis, which tells you everything about how fast people run when the liability becomes personal. 2 weeks after the ruling, I stood in my backyard with a rake and a wheelbarrow. The asphalt was gone. The gravel was gone. A landscaping crew I hired had regraded the soil and laid fresh compost across the footprint. I rebuilt the first 4 raised beds myself on a Saturday, while a game played on the radio. Cedar frames, hardware cloth, triple mix, same way I'd done it the first time. Slower now, maybe, but no less mine. Deborah came over with iced tea. She stood at the fence and looked at the new beds and said, "You know, most people would have just taken the money and moved." I told her I didn't want different dirt. I wanted this dirt, the dirt I'd been feeding for 11 years. The dirt that grew my grandfather's tomato seeds. The dirt that some woman in clean heels thought she could erase with a truck and a vote. That evening I planted the first new row. Cherokee purples, same strain my grandfather kept in a coffee can in his garage. I pushed each seedling into the dark soil with my thumb and thought about how Janet had called it shared infrastructure. I thought about how she'd smiled when she said adjusting. I thought about the 3 cold frames in that dumpster and the blueberry canes snapped in half and left in a pile like brush. Then I watered the row, washed my hands, grilled a burger on the patio, and ate it standing up while the sun went down behind the oak tree I'd been watching for 9 years. The lesson is simple. At HOA wars, the person with the survey, the stamps, and the patience usually owns the ending. And around here, dirt remembers who took care of it, even when the pavement tried to make it forget.